When people hear the word prenup, they often think it means planning for divorce. But in reality, prenuptial agreements aren't intimidating. They actually are a lot more practical. These documents are about four things: clarity, transparency, protecting separate property, and avoiding future conflict. If you own a business, expect a significant inheritance, have children from a prior relationship, or simply want to set a clear financial expectations before marriage, a prenup may be worth considering. However, Ohio laws only recognize these agreements when certain requirements are met. These documents must be in writing, signed, entered into freely, and based on full disclosure or full knowledge of each party's property. Hi, I'm Attorney Degenhardt with DuPont Law Group in Dublin, Ohio. We help families in Central Ohio with estate planning, elder law, tax planning, and probate. In this video, I'm going to explain what a prenuptial agreement is, what it can and cannot do in Ohio, when couples should think about getting one, and some common mistakes people make. So, what is a prenuptial agreement, also called a prenup? These contracts are entered into before marriage and address financial rights and responsibilities. In plain English, a prenup lets a couple decide in advance how certain financial issues will be handled instead of leaving everything to default Ohio law. A common misconception is that prenups are just for the ultra-wealthy, which they are not. Prenups can be useful for anyone that owns real estate, has retirement accounts or investments, owns a family business, wants to protect inherited assets, has significant debt, or is entering into a second marriage. So, what does Ohio law say about prenups? They are generally enforceable in Ohio if they meet certain legal requirements. These documents are valid and enforceable if they are in writing and signed, they are entered into freely without fraud, duress, coercion, or overreaching, there is full disclosure of full knowledge and understanding of property, and the terms do not promote or encourage divorce or profiteering by divorce. Ohio Supreme Court guidance also notes an important timing issue. If this agreement is presented very shortly before the wedding, and postponing the wedding would create significant hardship, embarrassment, or emotional distress, that can create a presumption of overreaching. All of this legalese boils down to this: do not wait until the last minute. A well-drafted prenuptial agreement can often address issues like what property each person is bringing into the marriage, how certain assets should be treated during the marriage, how debts will be handled, what happens to business interests, and in some cases, spousal support terms. But what can't a prenup do? A prenup is powerful, but it's not unlimited. For example, you should not think of a prenup as a catch-all document that can solve every future family law or estate planning issue. Issues involving children are generally handled based on the child's best interest at the time, not locked in by a premarital contract years later. That is why prenups are usually best understood as financial planning documents, not parenting documents. Even when a prenup addresses spousal support, Ohio courts may still review whether the provision is not correct at the time of divorce or not right for that family. So, why do people get prenups? The best reason to get a prenup is not distrust, it's clarity. A prenup can help couples have honest conversations about assets, debts, financial expectations, family obligations, and long-term planning goals. For some couples, that means protecting a business they built before the marriage. For others, it means preserving family wealth or inherited property. It means reducing uncertainty, conflict if the unexpected happens. And in a sense, a prenup is less about planning for failure and more about creating a clear financial framework from the beginning. Here are some of the biggest mistakes I've seen couples make in waiting too long to draft a prenup. Most courts in Ohio don't honor post-nuptial agreements, and if the agreement is presented right before the wedding, that can create problems and even a presumption of overreaching under Ohio law. Some other common mistakes are not fully disclosing assets and debts, using vague or generic forms, and treating it kind of like a DIY document. These agreements can affect property rights, support issues, estate planning, so careful drafting matters. A prenuptial agreement is also not about expecting the worst. It's about planning carefully, protecting what matters to you, and entering marriage with more clarity and few financial unknowns. If you are getting married in Ohio and considering a prenup, the key is to make sure it is drafted properly, signed voluntarily, and based on complete financial disclosure. Ohio law and Ohio's Supreme Court guidance make those points especially important. If you found this video helpful, share it with someone else who could use this information. And if you have questions about prenuptial agreements, estate planning, or protecting your assets before marriage, you can contact our office at 614-408-059 to schedule a consultation. Thank you.